HMRC and MR Currell Limited.
Yes, Mr. Coach.
I'm grateful. Please may I check? You can hear me. This microphone's on. Thank you. And good morning. I here with Mr. Waldegrave for the Commissioners, Mr. Elliott here for the Respondent Company. The court should have, please, a core bundle, a supplementary bundle, and authorities and 4 bundles of authorities.
Yes, thank you.
Thank you.
Yes, and some of us are using electronic bundles, so it would be helpful to have page numbers when appropriate, as well as volume numbers and tabs, please.
Yes, of course. Please, I don't think they've been handed up already. Can I hand up? This is just a note so I can be efficient. While I'm at it, please may I hand up an authority. Stuff, please. Thank you very much indeed. Thank you.
Thank you.
What I've handed up, first, my summary submissions on the facts. I will simply go through these.
Thank you.
And with the court's permission, what I'll do is explain why these facts are relevant. And of course, I'll make what I say here good. I'll show you the passages in the FTT and the UT I refer to. Tough place. I can't face talking about it for too long. The parties initially couldn't agree it was relevant. Now they agree it is relevant. And Mr. Waldegrave, in due course, will be making submissions on it.
Okay.
And with the court's permission, what I would like to do, please, is 1, make my submissions on the facts. 2, make submissions, my legal submissions, and then make those good. So I'll tell the court what these are, and then I'll make them good. And mapping my submissions, to trail what I'm going to say, mapping my submissions onto our grounds of appeal, we say, and I'm confident that this court has read the FTT and the UT decision, so the
Yes.
court's perfectly aware what this case is about.
Yes.
We say the payment from the company to the UT, that's earnings, that's ground 1. And the FTT got that right. And if you apply ranges properly, that's the right answer. That's 1. 2, assuming I'm right about rangers, even if the FTT got its decision, the archaeology of its conclusion wrong, so did the Upper Tribunal, so did the UT. They misapplied rangers. That's assuming I'm right about rangers. That's ground 2. Ground 3, the revenue's position, Mr. Waldegrave will develop this, is good short. This arrangement, which is payment plus loan or a loan looked at in isolation, can in certain circumstances, not all circumstances, nobody's saying that, can in certain circumstances be earnings. And this case is one of those. Ground 4, and this really goes hand in hand with ground 2, is even if you take the Upper Tribunal's analysis as being correct on its face to say, well, this case is, they say, distinguishable from the ratio of rangers. So say I'm wrong about rangers. The distinction, there were 3 distinctions. One, in rangers it was agreed the payment was remuneration, that's not the case here. 2, the Upper Tribunal says, in this case, unlike rangers, the loan gives rise to real obligations. And 3, in rangers, there was a side letter, a contractual undertaking to do this scheme, to pay the money. None of those are present in this case, the Upper Tribunal says. Even accepting that these are grounds of distinction from rangers, the Upper Tribunal's analysis as to why the revenue loses, that analysis is valid, you see.
Sorry, that analysis
Is valid. That these distinctions, even if they're distinctions which are right in principle, that makes this case different from rangers. Applying Section 62, applying the cases, the revenue should still have won before the Upper Tribunal. That's what I said. That's what we say about ground 4. But so we're clear. My primary case is ground 1 failing with ground 2. And this is actually it was now. This is of enormous importance to the revenue, because the approach of the Upper Tribunal confines rangers, the ratio of rangers, in a way that we say is wrong enough.
You say that this is of enormous importance to the revenue. Could you expand on that a little further, given the massive changes in legislation that there have been since the matters with which we're concerned in this case occurred?
Certainly. So, first, the ambit of rangers, which is, do you need a prior entitlement? We say no, you don't. So that's important. That's point 1 as point of legal principle.
Well, that's Lord Hodge made that clear. We don't need a prior entitlement.
That's true, my lady. But I will make that good as to why that the Upper Tribunal went wrong in their analysis. 2, why is it still important? Answer and structured. There are many cases standing behind this one.
This is adopting, as it were, the same scheme that originated this scheme.
Yes, and I'm saying in open court, this is identical to rangers. This is simply the same scheme as was adopted in rangers. It's a small company or a big company. But my respectful response to that is, so what? And my lady is, of course, my lady is right. The revenue thought they were going to lose rangers, as this court is well aware. So Part 7A was enacted.
So that was enacted in what, 2014 or 15?
The original legislation was 2011. It came in around about 2014. My lady's right.
I remember this from Aldeburgh.
Yes.
We dealt with the chronology, and it was rather curious because it was made retrospective to 2011.
Yeah, that's my point about it. That's where 2011 comes from. So, if my lady is saying, well, who needs rangers now because we've got Part 7A?
I'm not saying that. I was asking simply. I think you've answered it. The cases behind this one, presumably, therefore, are also pre-2011.
Yes. Yes.
So I'm not sure. I think you've answered my
Yes, yeah,
question.
you have. Can I just check, when you say cases standing behind this one, are they pending in the FTT or have they not yet reached that stage?
There are many cases at different stages.
Yeah.
Some are in the FTT, some are about to go to the FTT. They're all at different stages. And I'm grateful to my lady because that is my answer. Please may I look at this summary submissions on the facts.
Yes.
So look at one. This is the scheme. So you've got the company. It pays the say 100,000 to the EBT trustees. Then the money is lent to Mr. Currell. Mr. Currell, and nobody's saying this loan was a sham, and he understood it was a loan. He buys shares from Mrs. Currell, and Mrs. Currell puts the money back into the company. That's the scheme. Step 1 and 2, that is Rangers. Step little a, that's the earnings. That's my ground 1. That is the world in which, in Rangers, an employee says, when it's been put to the footballers and the executives, if you pay me salary of 100, I'm taxable on it. Don't pay me, pay my mama. And I'm happy about you paying my mama, because she's my mama, she'll lend me the money. That is Rangers, nothing more. And that's step A and step B right there. So if it's clear, and whereas in Rangers it was clear that payment was a quid pro quo for work done, here we say, and I'll come to this, but it's as well to trail it. It's a finding of fact that the loan was made for work done by Mr. Currell as the director. Nobody's arguing to the contrary in this court. And the purpose of the payment, that little a payment, was to fund that loan. And the company knew that. That's why we say that payment was for work done. It's not like other cases where there was a fight about, well, maybe it was a disguised distribution. We're not in that territory, we're not having that conversation.
In just one, because one thing that will no doubt go on to this in detail is the process of reasoning of the FTT to look at the payment and then. But can I ask you this question? One thing that is clear from the FTT's decision is that the payment and the loan were, they used the expression pre-wired. One was not going to happen without the other. But if you just, let's say you then, in a Ramsey sense, you ignored the payment and just looked at the loan, I think you accept, or from your summary you would accept, that most loans, or at least many loans, would not themselves be remuneration.
Yes, I do. And can I, with your permission, can I respond now? Because it's a point I'm going to come back to because it's relevant to ground 3. The diversion, the redirection of earnings, that's the big message from Rangers. Don't pay me, pay my mama, for my mama replan the EBT, because they're going to lend me the money. If you've got a loan, is that right to say that the loan can never be earnings? Now, I don't want to be painted into a corner where to say in open court, in the vast majority of cases, a loan isn't earnings. And I'm not running away from the question by saying it's fact sensitive. What I'm going to say is this is our ground three. Where a company makes a loan, where an employer makes a loan, but this is true of any creditor, any lender. A lender behaves as a lender when they make an advance, and that money is to be paid back. And it doesn't matter whether it's interest-free or interest-bearing, that's what a loan is. It's an advance of funds, and the borrower is on the hook to pay that money back. Where that transaction is covered by something else, something other, which is, yeah, I know you're going to pay this back in 5 years or 10 years, but don't worry about it. That may not happen. There is an inquiry to be had whether that transaction, yes, it's still a loan, nobody's saying it's a sham, but the person making the advance of funds is doing something else, something other than just behaving as a lender. And in a world in which the loan's not a sham, but the employer is saying, here, have this loan, but actually, if you don't want to pay it back, nothing's happening. It is legitimate to make the inquiry, is that loan earnings? Despite the fact that it may one day, because it's not a sham, have to be paid back.
That proposition is equally capable of being true in an arrangement that doesn't involve an EBT at all, isn't it? A direct loan by an employer to an employee on a nudge-nudge, wink-wink basis, you would say, is capable of being earnings.
I'm saying that's true of any loan. Yes, my lord. And I really don't want to go there, but
Well,
you
unfortunately, you may need to.
this is a place where I'm going to just make one point, but I don't want to advance this point unless you need me to, and of course I'm going to. This court will be perfectly aware of so-called perpetual loans. They've been in the market for a very, very, very long time. They're recognised as debt, but they're literally commercially perpetual loans. There's no obligation to repay. There's been a debate for ages as to whether they are true loans. And the orthodoxy is, as this court well knows, oh yes they are. All I am saying is, there is a world in which a non-sham loan, because of the circumstances surrounding the way the advance was made and the circumstances in which it's going to be repayable, may behave in a way that it's a reward. It's earnings.
But wouldn't you need facts by the fact-finding tribunal to make that? As you said, it's a fact-sensitive inquiry. So where is the finding of fact that here it was all nudge, nudge, wink, wink?
Well, if I go through this, then if my lord lets me go through this, I will pick up those facts which I say, and this is all ground three. This is all ground three. I'm not running away from the point, but it's ground three. I will say these are the facts that we are going to rely on to say ground three is good. If you don't like it,
well, we interrupted you. Yes.
But that is my response. As I said, the court may not like it, but that is our response.
You must go through your summary on the facts. Yes.
So, sticking to the scheme, A and B, earnings, and just like Rangers, Mr. Currell is happy about that because he's going to get a loan, and he knows he's going to get a loan. That is just Rangers. What he does with those earnings is C and D. It's all pre-wired. He buys the shares from Mrs. Currell in order to avoid the cheap loan provisions. And she puts the money back into the company. So what he's bought with his earnings that he gets at the combination of A and B is this tax-free access to 800,000 in the company. That's what he's bought. He's not bought a boat or jewellery or house, he's bought this. So the earnings have been utilised in this pre-wired sense at C and D. Conceptually, there's no difficulty with that description of the scheme at all. And then going through, and that's my big message. That is what the scheme achieved, in my respectful submission on any view. Tax-free sum paid, not to Mr. Currell, but to the trustees, so they would lend him the money for work done by him that he could then use to buy something, and that something is this tax-free access to 800,000. So he and Mrs. Currell together controlled the company. They're 31% of the company each. He built the business up. He was a driving force, to be clear, not the driving force. So this is all connected. The reason I'm giving you this is all connecting the proposition that, of course, the loan was for work done. We've got that finding. This is why that finding is good. And the payment was to fund the loan. Non-distribution. Nobody's saying it is. He'd been under-rewarded. The contract managers were paid more than him. 5 and 6. The payment didn't replace salary. And absent scheme, it wouldn't have been paid at all. And here my, again, respectful submission is so what? That is simply saying, I've not taken the salary so far, and unless I can do this tax-free, I'm not going to do it at all.
When you say so what, can I just pause, because you also rely on what you say is under-rewarding of Mr. Currell. Under-rewarding rather implies, well, he should have been paid more and he would otherwise have been paid more, but that's rather goes against what the FTT found.
Oh no, I don't accept that, my lady. Not at all. He should have been paid more. This is giving him access to that more. And he's only going to do it if this is tax-free. Otherwise, he would have had to look for a different way to be paid. But that's a separate conversation. All this is saying is that this sum wouldn't have been paid unless it was tax-free in this scheme. It wouldn't have been paid. That's all that's saying. This 800,000 wouldn't have been paid if they hadn't done this. He would have had to find a different way to make up for that under-reward. That's true.
And he might have found another way of doing that, which might or might not have attracted income tax on earnings.
That's right.
You accept that? You have to. And this is commonplace that people will engage in a number of different transactions, which may or may not be tax-free. But why does that mean that they bear the stamp of being earnings?
Because the reason that he got the loan was for the work he'd done. That is consistent with, and the proposition that this is earnings is consistent with this observation that he'd been under-rewarded. So absolutely, that under-reward he could have looked to get in some other way, just at the end in years to come, salary, or in capital form. For what? For work done. And so all I'm saying is that if in asking whether this 800,000 is earnings, it is consistent with that proposition to say it was for earnings, for work done. Because he had been under-rewarded. That's all I'm saying. I don't need to push it further than that, but it is relevant.
Right. So you've got to sit.
As my lord says, it's a commonplace. So that's actually consistent with the revenues case.
Okay.
You've worked hard. You haven't been rewarded. Is this consistent with the proposition that money paid to the EBT, then lent and made available to you to buy something, is earnings? Tick. That's what I'm saying.
right? So we're down to 6
Yeah,
and 7.
payment was made to fund the loan, that's my point.
Yep.
The loan was for work done, payment was to fund the loan, the payment was for work done. That's what I say about that. 8 is pre-wired point, everybody knew at the time the money went in, all of this was going to happen. The company knew, that's 9. And then you got the express findings that the loan was for work done, and that informs what the payment was for. Uh, 11. The loan was interest free, this 5-year loan was interest free, but if it was a bad lever, it took interest. That connects the loan to the directorship. The trustees were reactive. This is all driven by what Mr. Currell wanted. That's what it is now. 13. That makes good what I'm saying about what is it he bought. He bought this access to 800,000 that he could do what he wanted. That's 14 as well. 15. This goes back to the points put to me by the court. Will be available to him to draw without a tax liability. That's what he's buying. 16 is the same. It's not true that the payment was made to ring fence bonuses paid to anybody else. That's 17 and 18. And apart from 50,000, that loan is unpaid. Then we've got that's 19. Then we've got 20. And this is annoying, I'm not going to lie. You've got the FTT saying, the reason, it says it more than once for your note at 15, paragraph 15, subparagraph 31, as well as 16.8. The reason why the trustee made no demand was because of this double tax. But then that changes to one reason at 36, and that should be sub 14, not 13. Now, this I need to address because it's something to plug into my submissions. 1, the double tax here isn't true double tax. It's not one person being taxed twice on the same receipt. This is a different type of double tax, which isn't true double tax at all. It's saying an identifiable sum of money can be taxed twice. I get barrister's earnings of 100, and I spend that money in Tesco's. That 100's taxed again. It's not double tax. So what's being said here is that the concern, and you'll see it's good, of the company as well as the trustee. So it's the company here that's having the concern. Its wishes didn't want to fund bonuses on a repayment of the loan out of what is effectively taxed income. That's all that's saying. Where does this observation take us? Didn't stop the FTT finding that the payment was earnings. If the proposition, and you can't tell, looking at this, the reason means that the only thing stopping the repayment of the loan was the worry about double tax. That was the only thing. The inference being then, the loan would otherwise have been repaid in 2015.
Sorry, maybe you need to rephrase that. Are you saying you can't, even though the FTT refer to the reason in 2 places, they're not saying that's the only reason?
I'm saying that they've changed to one reason expressly so in 3614, so it is not safe for this court to say that the only reason, the only thing
Tell us
stopping
what the other rival reasons might be, do they?
got a scheme that gives him 800,000 tax-free out of the company. He doesn't
In
want that
terms
to
of
end
an
up with money.
FTT finding,
I'm sorry,
in terms of an FTT finding, they never say, and the other reason was X.
they don't say that, but they tell us why the scheme was put in place. And having that scheme as a 5-year scheme, let's see where that takes us. Let's say that we're in a world in which the FTT, what it's actually found is that the only thing stopping repayment for the worry about double tax. Let's say they are saying that. I don't accept they're saying that, but let's say they are. Then we've got a 5-year scheme. So in year 5, what Mr. Currell's got to do, what he's got to do, is find £800,000 of his own money to repay the trustees in order to continue to have this £800,000 access. So it's behaving like a bridging loan, a tax-free bridging loan. Now, that is a weird scheme. But even if that, and there's nothing that suggests this scheme was a 5-year scheme. But if that's right, that doesn't disturb my submissions. I don't have to run away from this. I'd say, well, if that's the reason he's done this, diverted earnings so he could get a 5-year bridging loan, that's on him. But it is inconsistent that the only reason stopping repayment was the worry about tax, the inference being that it would otherwise have been repaid in 2015 with what it is he's bought with that money. But it doesn't disturb anything I say about ground 1 or ground 2. That's all I want to say about the competition between the reason and a reason. It is not safe, in my respectful submission, for this court to assume the only reason, not when the court talks about one of the reasons. This makes it clear what it was that Mr. Currell was buying, because the only reason he bought shares from Mrs. Currell and then she put the money in was to escape the charge that would otherwise have been fixed on under these cheap loan provisions. My lady is clearly familiar with the provisions. For what it's worth, it's in ITEPA section 174, 175, 178. There's a history of paying bonuses, not to Mr. Currell. And what the FTT made of that was in the 5 years, nor any view, that the loan was on foot, those bonuses would continue to be paid. That's what they said about that.
Sorry, they say bonuses were continued to be paid.
They assumed it would. I'll show you the passage in the FTT.
Okay.
So what they were saying was, this is really part of them rejecting that this 800,000 was in any sense a ring-fence sum to pay bonuses to anybody else out of. The EBT was a means of rewarding employees. Here, I'm just saying, yeah, exactly. Yeah, Mr. Currell. And the background to all this was tax advice.
Can you also, while we're talking about other provisions, you've touched on the cheap loan provisions, the other provisions that might have applied, but obviously were not regarded as applying, were the loans to participators. My recollection is those were also broadened at some point and may now catch this arrangement.
Yes, and again, I don't carry that in my head. It was set in section 455.
But there were some significant changes to those provisions.
Yes.
I mean, the revenue's obviously taken the view that they don't catch this, because that would have just imposed a straight 25%.
Exactly right. But and if the court wants or needs me to, then of course I'll come back to the revenue's position. But here, what we're saying is, in a world in which this payment was earnings, the correct rate of charge is income tax, employment tax plus NICs. the laws to participatory provisions are to disguise distributions in small companies. That's where the 25% comes from. So
Yes, but it's the classic way in which loans to directors of close companies get taxed. Whether or not they're taking PAYE earnings, very often they don't.
that's true.
Let's not spend time on it.
But
But
to
it's
me-
set. You've reminded me of the section number.
Yeah,
Anyway.
it is 455, and and if you need me to, I'll come back because I as I say, I do not have that in my head. But the burden of this case is not, in my respectful submission, ought not to be. You can't get me for this job. I was doing this other job down the road. This was in truth a loan from the company, and this was all not earnings at all. This was all to do with the loan from the company, which should have bought 25%, but we managed to dodge that. No, this scheme that was put was the Ranger scheme, and it was for work done. He was under-rewarded. Don't worry, you can get that money and get access to, as it were, get the actual fund notes. Tax free.
Can I again? You mention under-rewarded, and the FTT do refer to that concept in their reasoning. But I may have not picked this up. Was there anything in the evidence or their earlier factual findings that, to the effect that it was recognised that he hadn't been paid enough, hadn't been rewarded?
This, I'll show you this. They recorded the relatively small sums that he'd been paid as a combination of salary and dividends, and that the contract managers were paid more than him.
Okay, yeah, you've made that clear, thank you.
So that if you're asking where the FTT legitimately got that finding of that from, it would be from there.
Well, whether it's an finding of fact or part of the analysis, you can debate, but they
Well,
clearly concluded he had been under-rewarded.
I say an under-reward is a finding of fact. That's a description of the word. Is the material to make that finding from tick. Where it plugs, of course, into the analysis is that is consistent with this sum being earnings. That's what I'm saying. That's no more, no less than that. If I'm under-rewarded and haven't been paid a salary, I haven't paid dividends. It's consistent that this money, if it's for work done, is earnings. That is literally all I'm saying.
Thank you.
So, just to let the court know, I promised my team I would share this with the court, but I've got a very sore knee, which means if I'm wincing, it's not you, it may be that I ask eventually to address you sitting down.
Yes.
But anyway, I don't trail that.
Please don't hesitate.
Thank you.
And if you need a short break or anything we can do to help, we will.
Yes, thank you very much, and I'll let the court know. Now, these are the submissions I want to make. That's all I want to say about the facts, and then then I shall. These are the submissions I'm about to make.
Yes.
So you've got the scheme. Earnings, lent, used to buy something, is something is a different something to the something bought by the Rangers footballers or the Rangers executives. I do want to say something about the charge on earnings, and I'll take it short, but it is important. And I'll show you this. If you have, please, it's in the first authorities bundle, and it's tab 4, page 24. I'm hoping that's right for the electronic bundle. Please may the court let me know if
Section 6.
6 of ITEPA.
Yep.
So that's the charge on earnings, and that includes general earnings, which is section 62. So we know that. And I'll look at section 62, but that's the charge on earnings. Section 9 little 2, that's at page 29. That taxes net taxable earnings. Section 10 little 2, that tells you what taxable earnings means. That's at page 30. Section 15 little 2, that's at page 35. And this is why I'm showing you this. This is, in my respectful submission, this is important. Tax the full amount received. And that word received became a thing in Rangers. If I don't receive money, you can't tax me on it. That's why section 18 is really important. That's page 39. Because if you look at section 18, received means payment. Simply means a payment of earnings. And the archaeology of this tax charge, this is how tax works, what the draftsperson is saying. And this hasn't changed since this was the same pre-ITEPA. Is what he or she is saying is what I'm taxing is a payment of earnings. They have to be received by the employee, not at all. That's why don't pay me, pay my mama doesn't work. And that is the starting point. And the PAY provisions apply if we've got general earnings. So the huffing and puffing that went on during Rangers about, well, the employees weren't receiving anything except the loan, forget it. And once you see that point, it's impossible to unsee it. Don't pay me, pay my mama. Really? No. And that's what's happened here. Tax laws will call it source. Then we look at section 62. It's on page 43. And just for your note, the PAYE provisions, they track what I've been saying about receipts equals payment. Section 686 establishes rules. It's not in the bundle, but the PAYE provisions are consistent with what I've been saying about section 18.
And we assume, we're asked to assume, as the tribunals did below, that there's no material difference as regards NICs.
Yes, ma'am. Please, if you look at page 43, there's your section 62. Now this is a change as it happens from the old section 19 from the Tax Act 88. So if you look at, please, little 2, little a to c. A is about salary. C is other emoluments. So between A and C, they capture all emoluments. So little b, quite literally by definition, is capturing something which is not an emolument, these gratuities or other profit, doesn't use the word emolument, or incidental benefit.
You're not really relying on B, are you? And as Lord Hodge pointed out in Rangers, in fact, that's the one provision that requires the employee to obtain something directly. I mean, if you're relying on anything specific, you're relying on C, as I understand it.
A or C. You either say it's a kind of catch-up salary or it's C under the moment. And it's not, that's to make sure you're not shoehorning this payment into something that seems wrong.
Mm.
If it's a payment where the substantial reason that payment was made was work, the employment, then yeah, of course, the revenue's indifferent to whether it's within the grey areas. And as we know, as it happens from rangers, that a discretionary bonus isn't a gratuity. Of course it's not. It's no more than, even though it's discretionary, even though you've got no contractual right to it, it's not a gratuity. And they were taxable. Looking at the Supreme Court's decision in Rangers. So it's the same rules that apply to salary, even with footballers. The footballers had side letters, the executives didn't. Gratuities have to be according to the Supreme Court, so it finds all of us received, doesn't matter, the executives' bonuses were taxable. So I wanted to show you the archaeology of the charge, because looking at what I've shown you about section 18 and section 62, we're looking for whether there was a payment of either salary or some other emolument. That's what we're asking. What does that mean? The test is common ground. The substantial reason is work. And that is my, now I'm going to bleed into my submissions in ground one. The loan was for work. That's an express finding of fact. The payment was to fund the loan. And I'm sorry, this is terrifically boring because I've said it so many times. So the payment was for work. And if that's right, this is just Rangers. So, looking at ground one, this is what I would, this is what I want to say. The payment was made for work done. There's no other, in my respectful submission, there's no other legitimate inference of fact. The loan was for work, the payment was to fund the loan. Everybody knew exactly that. And in parentheses, even if you think that was a true 5-year loan in the sense that the only reason the loan wasn't repaid in 5 years was this worry about this double tax, that doesn't change that. It means he's diverted his earnings to give him a bridging loan. But I hope I made it clear. I don't accept it as that's the only reason they stopped the payment. And I go on to say, and you've already heard this, it didn't replace salary, that's not relevant. It wouldn't have been paid absent scheme, that's not relevant. It was, now, this is Rangers. The fact that the payee was the EBT, that is jurisdically, legally irrelevant, and that is just Rangers. Now, looking at the terms of the loan, it was said, and it was a central part of the Upper Tribunal's reasoning, that this loan had real obligations, genuine obligations. So did Rangers. The reason that the revenue kept losing, and I'll show you this, the revenue kept losing Rangers in the first year tribunal and the Upper Tribunal, because the thrust of what the revenue were arguing was that, well, one way or another, the loan is earnings. And what both the first year tribunal said and the upper tribunal said was, well, no, that's not right. What the revenue then did in the division, in the inner house, was to say that the loan's an irrelevance. This is just somebody saying, what I've said to you, don't pay me these earnings, pay my mama, and I'm cool about it. But to test that proposition, it was never seriously argued that the payment was anything other than for work done. But to test the proposition that that was the true, fair description of the scheme, of course, one interrogates not just the legal terms, but the facts surrounding the loan. In other words, why are you cool about it? Why are you willing, instead of you receiving this money as salary, why are you happy that it's paid to someone else? Answer, because I know they're going to lend me the money. I know they're not going to be difficult. And in Rangers, you've got this express finding that there was an expectation that the term, the loan would be rolled over. Here, you haven't got that. What you've
Yes.
got, sorry, my lady.
Yeah, I mean, one other distinction in Rangers also was the subtrust arrangement.
That's true, my lady, but I don't think that's a relevant distinction. All that happened was that the big trust formed sub-trusts for each football.
Indeed, but it is part, it may be part of the relevant context that the funds, even if lent out, if they were repaid, would find their way back to a sub-trust for which the footballers were the protectors.
And that would be part of what makes the footballer feel safe. That's true. Here, and because that Rangers was a big company, the footballers had no control. Here, this company is controlled by Mr. and Mrs. Currell. Who needs all that? We know the trustees were reactive, and we know that Mr. and Mrs. Currell controlled the company. It's like, I'm about to come on to the side letter point. You don't need those safeguards if you're there, right, in a small company.
Just rolling through what happens here, repayment of the loan.
My lord, I'm very sorry.
I'm so sorry. Here, unlike Rangers, repayment of the loan would not go to a sub-trust of which the employee was the protector, of which his family were beneficiaries. It would go effectively back to the principal trust, I suppose, in Rangers terms, with a much wider class of potential beneficiaries.
That's right.
On which it might then be capable of being awarded as bonuses to other employees. Indeed, we're told, at least at one stage, for reasons that I'm conscious were controversial before the FTT, that to some extent did happen.
I think that's the same point as my lady's just made. And my point is, and my response is, I understand that. But given that Mr. and Mrs. Currell controlled the company, and given that the trustees are reactive, and I'm about to come on to my observation, that apart from this 50,000, the rest of it hasn't been repaid, they don't need the same safeguards as an employee in a small company. The footballers couldn't control what Rangers did. Not even the executives could, except for one, who surely decided his own bonus. So, Mr. and Mrs., in my respectful submission, the observation that the footballers were, sticking to them, were protected because if the money got repaid, it was a sub-trust and that sub-trust was for them and they were protected. Why is that relevant? It's relevant because it shows that they were happy for their salary to be diverted from them to the main trust to the sub-trust. They were happy. And this protection confirms why they were happy. And I'm saying Mr. Currell here was happy. He didn't need that same protection because he and his wife controlled the company. That's it. You can't elevate this to an analytical proposition to say that that is relevant to whether the payment was earnings or not. We've had that conversation, it was for work done. If that's not true, then the revenue submissions fall. This is all to do with the conversation we're now having. This is all to do with were those employees and rangers happy for this money to be paid to the main trust? Tick. Why? Because it was a sub-trust. And they knew it would be lent to them. And even if they have to pay the money back, it would still be there for them. I'm saying all of that is true here because Mr. and Mrs. Currell control the company.
Can I just go back to one point and make sure I've understood what you're saying? You said several times the payment was for work done, but at one point a few minutes ago, I think how you got there was by saying we have an express finding of fact that the loan was for work done, and you therefore, as I understand it, what you say is it must therefore follow that the payment was because it was made to fund the loan. Have I understood?
Yes, my lady.
That is the way you put your case.
Yes.
There is no express finding of fact to state the obvious, therefore, that the payment itself was a reward for services.
No, but let me trail this. No, there isn't. Except, when I show you paragraphs 55 and 56, might be 56 and 57, 56 and 57 of the FTT decision, the FTT actually says, therefore. So they say that
In their conclusions.
Absolutely
yes.
right, my lady.
Okay. Now,
That's how they got there.
if I recall, ground one is put on the basis that the FTT didn't err in law, and some of the I'm sure you'll come on to that, but some of the argument is, well, they correctly focused on the payment. But it seems to me that you're making the loan an essential part of that reasoning in what you've just said.
I don't think that would be fair. What I'm saying is this, that to understand the scheme, that don't pay my salary to me, pay it to the EBT, to make that good, it is absolutely on me, it's on the revenue to say, I can tell you, by looking at the loan, why, number one, the payment was for work done. That's something I'm allowed to look at and I should look at. And two, why I feel safe that that's fine. So in interrogating whether that payment was for work done, you not just can, but must look at the circumstances why the loan was made when we know that the company knew that's what the money would be used for.
I mean, this may get to the crux of the appeal, but one thing that's, speaking for myself, I think those others on the bench, be helpful to understand a bit better why the FT went about its reasoning in the way that it did, with quite a substantial section in the middle on whether the loan was, I think it used the terminology reward or benefit. And I think this is what you're getting at in the part of your submission that I just diverted to.
Yes, that's fair. Because what I'm saying is, the tribunal, the FTT this is, asked itself whether the payment was for work done, whether it was a reward for services. The way they did that, the way they found that out, was to ask themselves what was the loan for. And that I say is legitimate. Because what is I've said it, they have to show two things. They have to show that the payment was for work done. If the company knows I'm making this payment for no other reason than to fund a loan for work done, that's a perfectly legitimate inference.
Thank you, that's very helpful.
And that's why that word therefore is so important in 57, I think.
Yeah.
And then the second thing they have to show is, well, you're telling me this was all a scheme, you the revenue. Why did Mr. Currell feel safe? And so, of course, you have to interrogate the circumstances of it. Absolutely. Because I've got to show two things. I've got to show number one is an emolument, and number two is a payment. I'm saying there's an emolument. I don't think you need to repeat why payments got work done, it was to fund the loan. That factual, mixed question of fact and law, that proposition that payment into the EBT was for work done. I've explained exactly how I've got there and exactly how I think.
No,
payment into
you've made that very clear, and that's very helpful. Thank you.
And I then say, has it been a payment? Well, tick. The money's unreserved at the disposal of Mr. Currell because he's lent the money. That is Rangers.
Well, you don't need to go that far because you say the payment.
Yeah.
The payment is the.
Well, that's true.
That's the end of it, isn't it?
And all I'm saying, my lady, is sorry.
And the unreservedly is at disposal. I mean, Lord Hodge tells us to be careful about that. So.
It's true, my lady. I think all I'm saying is that's why I keep saying I'm going on and on and on about how this is just Rangers.
Yeah, I think we've understood. Thank you.
And then let me then make my last point about this side letter, this notion of a prior entitlement. Now, this has got traction as seemingly a restriction on the ambit and the application of Rangers. Now, what the footballers had in Rangers was a side letter that said to each footballer you'll get 50 salary, just normal salary, and don't you worry. You want 100. We're going to put 50 into this sub trust. It's terrific. And what the side letter says is you must put that 50 into the sub trust. They had that. Now, the executives didn't have that. That's an express finding. It's all over the place in Rangers, and I'll show it to you. It was a discretionary bonus. It's saying to someone, it could be saying for any reason at all, you've been terrific, you're not due this money, have some. You've been terrific, you think you're leaving. Don't leave, I'll give you a bonus. Those discretionary bonuses were expressly by my Lord Hodge given the same tax treatment as the footballers. He uses the word same. And so there is no need, in my respectful submission, on any of you, and it's important to the revenue, that what we established, what the revenue established in the Supreme Court was that the notion of source is important. You got this money as taxable. And I don't care whether you've got a prior contractual arrangement or not. That would be a terrifically narrow.
You remember the Inner House described the executive payments as wholly voluntary on the worst part.
Yes, they did, my lord. They absolutely did. So not a tip. Gratuities and tips, they come from someone other than the employer. That Calvin and Wainwright, which I think it's in the bundle, I don't plan to show it to you, but it's expressly described, that kind of payment as a payment coming from somebody other than the employer. We're not talking about that kind of gratuity, and when it is that they are and aren't taxable. So that's right, I'm right about that. And I'm going to try and take this short. What we see is, if a payment is for work done by inference, that's bearings all right. Absence of side letter, irrelevant. Genuine obligations on the loan, irrelevant. And any sort of prior entitlement, irrelevant. And that's what I'm going to show you when I look at Rangers FTT Upper Tribunal, that's really not going to take very long, and the Supreme Court. You can have different cases, just to trail what I'm going to be showing you when I show you these cases. A case like O'Leary was a footballer again. But what was said there is that was a different scheme. The employer puts 266,000 or whatever it was into a trust, but they were never going to let you, the footballer, get your hands on that money. What they wanted to give you, pay you, was the interest arising from that money, and that's employment income, all right. It's a different scheme. Ford and McHugh, that's quite an instructive case, because my Lord Hodge again. Money goes into a FERPS, an unapproved benefit scheme. And there's a tax charge if and when that money is paid out to a pensioner, to a beneficiary. And what the revenue said in the Supreme Court is, oh well, the money is taxable going in. And my Lord Hodge got himself up into a rage and said, so you've got two tax charges, one going in, one coming out. Mad.
Yes, he was clearly very affected by the double tax point in Ford, wasn't he?
Well, it's a standard analysis to come on.
But it's a significant point.
Yeah. And that's why I was careful to address the point about what double tax actually means. Now, because if a pensioner predeceased their entitlement from the firms, the money went back into the trust. They never got it. Now, what he says at the very end, and the court may recollect this, he actually says, in terms, I was not addressed about whether this money going into the FERPS, into this unapproved benefit scheme, was a redirection of salary. He says that. I mentioned Smith and Stretton. Now, when I show you strategic branding and CIA, when I say the Upper Tribunal in this case, so I say that when I show you the FTT, if you accept my submissions, if you think I'm right, the FTT asks, is the payment earnings? I'm going to look at the loan in order to infer whether the payment was earnings. In my respect submission, I succeed on ground one. If and there was no error of law. Even if there was an error of law, what I say, and this is ground two, the Upper Tribunal made these distinctions of this case from Rangers. And they said, oh, well, I said it was agreed in Rangers that this was remuneration for work done. I'm saying here we've got a finding. Findings. They say, well, in Rangers, the loan got deferred, rolled over. I say they were every bit as genuine in Rangers. That was a finding. That's why the revenue kept losing when they kept attacking the loan.
I'm sorry, it's my fault. I'm not following that. This is on the hypothesis that you've lost ground one.
This is on the hypothesis.
It seems to be arguing ground one again.
No.
No?
I'm saying I need to be right about Rangers.
Right.
But there was something that was bad about the way the FTT went about its decision that meant it was correct for the UT, the Upper Tribunal.
Oh, I see.
And I'm saying you shouldn't have, but if I'm wrong about that, it was correct to the Upper Tribunal to interfere, set aside the FTT. But now I'm saying, if I'm right about Rangers, they got it wrong in applying Rangers.
Yes, I see.
And what I'm saying about, sorry, give me a minute. What I'm saying about that is the Upper Tribunal said, number one, it was agreed that this money in Rangers that was redirected was for work done. I said, we've got that here. Findings. Number two, the loans in Rangers, and this is where I say the Upper Tribunal went wrong, are different from the loan in this case because this case has got genuine obligations, and so did the loans in Rangers. So that's not, in my respectful submission, a ground of distinction at all. And then 3, they say, oh, there were side letters or other entitlements. And we say, well, not when we're talking about the executive bonuses. And when I show you 2 cases, one's called strategic branding, and again, this is not going to take long, and the other one is, what is it called? CIA. My redirection, it was me, redirection point, that was rejected by the FTT on the basis that the loan was a real loan, and that wasn't the point of my submission. The point of my submission was what was the money being redirected. That was the earnings.
Sorry, your point of your submission where in those cases?
Yes.
Oh, you were in those cases.
Yeah, I was
okay.
in all these cases, so I don't know what I did wrong.
You're trying to put it right now.
Well, I tried again in Marlborough, because in Marlborough, it was the same. Road ranges. And I said, well, why isn't this money being redirected? Just earnings. And the FTT said, no, because in that case, in Marlborough, it was a distribution.
Mm.
That was a whole different conversation. My Lord Justice Singh will recollect.
Mm.
So Marlborough was not relevant to anything. So that's my ground 2. And with the court's permission, Mr. Waldegrave will address you on ground 3 to say, well, if you're wrong about all that, then the payment plus loan, or the loan looked at in isolation, that can still be earnings. That's Tuffley's, because that's exactly what the FTT found. And just to trail this, and Mr. Waldegrave will be addressing you, I say this respectfully, incomprehensibly, the FTT, having decided Tuffley's before, so after the division decided the case in the inner house, but before the Supreme Court said, well, the division's case, that decision doesn't bind us, and so we're not going to follow it. They then were asked to review their decision after the Supreme Court, and they just said, no, we're not going to do that. They said Rangers doesn't apply, but the payment plus loan is earnings. That's exactly what Tuffley's decided. Mr. Waldegrave, as I say, will address you on that. And ground 4, and that will also be Mr. Waldegrave, will say, that's to do with saying, I've said, look, even if I'm wrong about Rangers, and I don't think I am, but even if I'm wrong about Rangers, the way the Upper Tribunal went about its business of deciding this case, it misapplied the law even on its own terms. So please, can I show you Rangers? I need to get my this is tab 27. I'm just going to show you the 2 important decisions are FTT and the Supreme Court. Tab 27 is volume 3 of the paper bundles, page 602.
Yes.
And what I'm going to show you here is simply how voluntary the bonuses to the executives were. That's what I'm going to take from these passages I'm going to show you. So, paragraph 12 on page 647. That just tells you there had been a previous pattern of discretionary annual bonuses, but there was no contractual provision for these. Says nothing. Paragraph 39, these names were at that stage anonymized. Page 611. one of these directors, he wasn't a footballer. He determined his own bonus. Paragraph 59, page 616, that mentions the side letter. I'll come back to that. Paragraph 16, that simply reiterates this now familiar excuse me, point that there was no contractual right to the bonuses for the executives, only an expectation. Paragraph 68, that tells you what the function of these side letters actually were. There were two functions. One was to give these employees, the footballers, a right to make the payments into the trust. The second was to hide these payments from the SFA, from the Scottish Football Association, because there were rules about how much you could pay footballers. 103, page 624, very important, because these are the findings of fact the FTT relied on to come to its decision. And at 625, little 11, says in terms, the group's employees, other than the footballers, had no contractual right to a bonus. It was a practice to pay a discretionary bonus. Now, 186 on page 642, you'll see the focus, and this is making good what I was saying, that the reason that the revenue kept losing was because at 186 you're told what the FTT thought the issue was. It's whether earnings could extend to a loan. You see these at page 642. And then at 205, you've got the repetition that the executives, their bonuses were discretionary with no contractual entitlement. At 208, you've got mentioned the side letter again, and they say, well, that doesn't turn something which is not remuneration into remuneration. I think to be a fair way.
Sorry, just slowing down slightly.
Sorry, Mandy.
Okay, thank you.
And at 211, this is instructive because even the FTT at 211 is worth reading, because you remember Mr. Black, he decided his own bonus. Even this FTT said, well, about him, that might be a payment of earnings, all right. Exceptional considerations may arise occasioning PAYE-NIC in the case of Mr. Black, in view of his active control exercised generally over the group's activities, seemed to be able to decide his own bonus, apparently without reference to his co-directors.
Where did they take that observation, or didn't they?
Well, I showed you, it was the
No, where did they go with that observation? Did they?
It got lost because I don't know whether they actually ended up fixing a charge of him or not. This is a very long decision. I've looked, honestly, I've looked. I don't know whether he was fixed with a charge or not.
Okay.
On the face of it, why does the ability to determine the amount of the bonus of itself provide a relevant distinguishing factor in this context? I can see the ability to control what's done with it when it's paid, but least at the moment, it doesn't seem to me that control at that end of the process is necessarily relevant.
I don't want to say too much because it's just speculating. I just, you know, if you ask me to speculate, I'd say that there's an intuition that in that world where I can just decide I want to be paid this money.
It didn't stop there.
Yeah. But nothing good is going to come of me speculating that this was beautiful intuition that then morphed into what the revenue succeeded on eventually in Rangers. I'm simply saying, even for this FTT, they say, well, if you can decide your own bonus, that's remuneration, all right. But I don't know where that went.
So they seem, yes, they allowed the challenges to the assessments, didn't they?
Yes, they did. They absolutely did. Because if you look at 218, that's their conclusion. 218 and 220, they're focusing on the loan again. And that's why at 231, at page 655, what they're saying is, this is the phrase that resonated with the Upper Tribunal, it's a loan and no more. And that's why the revenue in attacking the loan, they lost again in the Upper Tribunal. And that's behind tab 29. And it's my Lord Doherty at page 772. The issue before the FTT records what it's all to do with. You've got loans. And he says, well, that's quite right. It's in paragraph 64, page 794. All they got was loans, not earnings. He says at 64.
Sorry, can you just give me the page number again?
Yes, of course, my lady. 794.
Thank you.
And what he's saying there is the FTT, nothing wrong with what they did, because the end result was what the employees received, loans, not earnings, no payment of earnings. So that's the so far so bad for the revenue, because the issue there was all to do with, can we tax a loan as earnings? And then we get to this, the division's not in the bundle, I don't think, but we get to the Supreme Court. And then the issue had changed. Findings of fact, I didn't quarrel with those at all. I said, this is me saying, don't pay me, pay my mama, really? And the Lord Hodge said, no, that doesn't work. So we start with behind tab 35, page 904. And at paragraph 1, see the issue's changed. The question is whether employee remuneration is taxable as his or her emoluments or earnings when it is paid to a third party in circumstances where the employee had no prior entitlement to receive it himself or herself. So that was the very issue. And I'll take what he says about the fruit boilers short, because what he says is summed up in the passages that I'll show you in the 50s. But at 31, page 917. It says in terms, RFC use the same trust mechanisms in making termination payments to players and in the form of guaranteed bonuses. Majority of the FTT discussed these and also accept certain exceptional cases. I showed you those. The other companies in the money group, which were respondents, use the same trust mechanisms when paying discretionary bonuses. There was no prior entitlement at all. Discretionary bonuses agreed on as a senior executives had no contractual rights. They were different to the footballers' bonuses, you can see that, which were agreed when they were signed up. But, he says, the bonuses, these discretionary bonuses, were paid as a reward for the work which the employees had carried out in their capacity as employees. RFC also used the same mechanisms of paying discretionary bonuses to its senior executives. And he absolutely knew, he absolutely knew that the loan would be rolled over. A lot of things that clear, but you've got my submission on that. And you'll see what at 34, where the fight was, and it's on that word received. That's why I showed you section 18. What Rangers were relying on was that nobody's received anything. And that's why at 36, my Lord Hodge says, well, I understand that. That's what this case is all about.
Well, he says should receive or at least be entitled to receive.
That's right, my lord. And he uses the word entitled. And he says, well, the employee neither needs to receive nor be entitled to receive the money himself. So that's right. That is right. But actually, just to show you this, this is again, please important. In paragraph 39, page 919. This is my Lord Hodge responding to my submissions. Just above that, you'll see he confirms what I told you about section 686 and PAYE, and that's about payments, not receipts. I see nothing in the wider purpose of the legislation which taxes remuneration from employment, which excludes the tax charge or PAYE regime. Remuneration which the employee is entitled to have paid to a third party. Now, some advisors seize on that to say, doesn't that just show there must be this prior entitlement? You can't have meant that because you've already seen he's talking about voluntary bonuses. So forget that. He is not saying the scope of Rangers is restricted where there's an entitlement to have the money paid to a trust. There was no side letter for the executives. And that would be a problem arising from treating words like a statute.
Why do you think Lord Hodge used the words prior entitlement?
I don't know. And I don't know. Because we know he's dealing with voluntary bonuses.
Yes, I mean, it might have been clearer for your purposes if we made it clear that there need be no entitlement at all at any point.
And he does say that because the trouble is that's the trouble with dissecting these judgments like a statute. He's been talking about the footballers, and they did have an entitlement not to have the money paid into the subtrust. He's gone out of his way to say there was no such entitlement to the bonus at all.
I think, yeah,
so
we're clear about that.
So he can't have meant that the scope of what he's saying is restricted to a world in which there was some entitlement of some description.
I mean, it's quite a good extreme case to test the proposition the employee must receive. If you say, well, hold on a minute, let's assume the employee has a contractual entitlement, you pay a third party. Can that make any difference? Answer no, that's the argument. But it doesn't necessarily follow from that. I think, as you say, the later paragraphs make clear that this principle in arrangements is only engaged where you have a contractual right that your employer pay the sum to the third party.
It can't mean that because the ambit of this, as I say, we are dealing with payments that were held to be taxable, which were voluntary, discretionary, no prior contractual entitlement. And this is why I'm saying it's a matter of principle. This is why I'm saying it's important to the revenue. Because you're sorry, Marie.
Yes, this particular paragraph, paragraph 39, I think is more addressing the footballers than the executives, isn't it?
It bleeds in, and that's the trouble because he bleeds in.
And then he adds the
Yeah.
executives on. But I think this particular paragraph addresses contractual arrangements.
And exactly the same is true of paragraph 41. It's right, I draw your attention to these. It's on page 920. Excuse me. Because he says, as a general rule, therefore, the charge to tax on employment income extends to money that the employee is entitled to have paid as his or her remuneration, whether it is paid. So again, he's talking about the footballers.
Yes.
And then he says there are exceptions. And please may I take the paragraph short. One is gratuities. One is perks, benefits.
Yeah.
That's paragraph 42. Paragraph 45 is gratuities. And paragraph 47 and 48 is the Ford and McHugh's contingent.
None of those directly in point.
No. And then he deals with what payment means, because then you do have to show two things. One, there's remuneration, and two, there's been a payment. And he deals with that in 52 and 53. That was 53 is the important one, because that's what's called Aberdeen asset, where what was done there was the employer puts money into an EBT, which then funds a company. And then what the scheme was there was that there was an option granted, which was supposed to dilute the value. So if they said there's £1 million in the company, an option was granted that was supposed to dilute the value of those shares, but it was never going to be exercised. And then one of the shares was passed to the employee to say, there you are, Smithers, all that money, that £1 million is in that company, it's yours now. And what the revenue said was, because by the time it got, this case went to the division, and it's in the bundle, but I think this is a fair summary of it. What the revenue said was by the time it got to the division, everybody knows that's remuneration of £1 million. What the taxpayer argued was, but it's not PAYE, because what he or she got was a share in the company. And what the revenue said was, you can get that money out anytime you want. That's a payment right there of money. Held, that's right. And as my Lady Justice Falk said, here, the payments to the EBT and the money, right, that's enough, but as it happens, the money has been lent to Mr. Currell. Now, I do want to show you Sempra. I don't mean to show you the case, I mean what my Lord Hodge said about it. And that's at 55, at page 924 and 925. So paragraphs 55 to 57. Because Sempra was a really annoying case where it was just Rangers. But the Special Commissioner said at the end of the day, all they got was a loan. Oh, come on. And my Lord Hodge, I said Sempra was wrong for many reasons. And that's what Lord Hodge says, it's just wrong. Those days have gone. And so I did want to show you that, because I say this case is Sempra. And at 58, he tells us what he says emoluments, taxable emoluments, what they look like. And he's looking at A and C, 62, little 2A and C. And he says they don't have to be received by the employee. And then he goes on at 61. He says the payment of money into the trust, what I said was earnings, that's the point of his earnings. It's a component of the remuneration, it's the money you get for work done. And at 61, the expectation of both the employer and employee is that the employee would not have to repay the loan. Now, as my Lady Justice Falk said, in my respect submission correctly, a lot of this is focusing on the footballers. It's 66 at page 927.
Is this the first time he really comes back to the?
Yeah. He touches on them, as my Lady Justice Falk has seen. He touches on them at various parts of the judgment 31. So he's making sure he's been careful not to forget about them. But for our purposes, and please read this. The bonuses which RFC and the other employing companies gave the executives were made available through the same trust mechanisms. See paragraph 31. The employees had no contractual entitlement to the bonuses before their employers decided to give them. So nothing at all. And here, if this was a labour law case, an employment law case, you might say, well, was there a right to be considered, whatever. What my Lord Hodge says here, no contractual right.
Well, he doesn't quite say that. He says no contractual right to the bonuses before their employers decided to give them, which isn't quite the same.
All I'm saying, my lady, is that insofar as this is at all relevant, he's not addressing a prior right to be considered. He said there's no contractual right until I've decided to make that payment to you.
Yes,
Quite difficult to see where there's a contractual right after they decided.
Yeah, well, it's not. It's like an interim dividend. It's exactly the example I gave to the court earlier this morning, where I said, please don't leave. Here's a bonus. Or you've done terrifically well. Here's a bonus. That's what discretionary bonus is. And what my Lord Hodge is saying here is you didn't have contractual right to that. He says that in terms. And I say that's a section 62, whether it's a little a or little c, it's an emolument. And it would be very odd if it's not. It's certainly an emolument, it's certainly taxable. The only question is, does it matter that you paid it to my mama? No. And the point raised by my Lady Justice Falk, I mean, it's addressed at least a bit when employees had no contractual entitlement to the bonuses before their employers decided to give it to them. That's one. Two, that doesn't go with the fact that the bonuses were voluntary.
Yeah.
He says you're taxable.
Yes.
You couldn't get a clearer steer. That the fact that there is no prior entitlement to anything until they've decided to give it to me. That's not relevant. And just to trail something which is on ground 3, if you court please looks at 69. It's at the bottom of this page, 927. This is to do with ground 3. Lord Hodge is saying, look, is it familiar story where a taxpayer who's done an avoidance scheme says, look, this doesn't, you can't catch me because look, you've got provisions elsewhere that would catch me. They don't apply to me. Doesn't that just tell you Parliament's happy or at least indifferent to me paying no tax? Here, he's looking at the cheap loan provisions. You see that? My Lord Reid did exactly the same in UBS. He said restricted securities, what restricted securities? And what the taxpayer said in UBS was, but there are express anti-avoidance provisions about devaluation elsewhere, which are triggered by avoidance. They don't apply here. And what my Lord Reid said is, we don't care about those. What I'm addressing is whether these are restricted securities and you've got these fake conditions. That takes me, or Mr. Waldegrave, to this question of just because it's a loan, can it never be can it never be earned? That's ground 3. But what I'm showing you here in my respectful submission is that if a payment's made for work, that's an emolument. If it's paid to a third party, that's irrelevant. And if there is no prior entitlement, that doesn't matter. That's why I'm returning to where it was when 10:30 this morning, and the fact that it may not have been paid, absent scheme, that is not my goal.
So what's the authority for that proposition?
Well, it's a function of the authority proposition that if money is paid for work done, that's a taxable emolument.
Sorry, when you say not my problem, I think I misheard the first part of that sentence. I think you said the fact that it wouldn't be paid absent the scheme.
Absent scheme.
Thank
So,
you.
just like Rangers, you will see that the reason they did this scheme was that they had to sign footballers who demanded a minimum net of tax salary. They wouldn't have got. So it's in that territory to say, well, I'm not coming if you don't set up this scheme and pay, or one way or another get me a net of tax salary of X.
That I understand. For ease of reference, let's use the kind of figures you were talking about earlier, 50,000 is the total package. But what if actually at the end of the day, because you've used a scheme, what in fact you have access to by way of loan is not 100,000, but 800,000, which is 8 times what you would have been paid by way of salary. Does that make any difference?
Yeah, because in the same way, that what you're saying is, I want money for that work done. If I can get it tax-free, I want more. It's not just the loan, my lord. It's the payment that funds the loan. I think that on ground 1, and for ground 2 is the payment by the company.
I'm trying to work out how significant the EBT element is in this. I mean, if I think I might have mentioned it, if the employer makes a loan to an employee without intending, as it were, to be particularly exacting about whenever it's paid back, you might get into an argument on the facts that constitutes remuneration. Does the introduction of the EBT, with that being the entity that makes the loan and the employer paying the EBT, make any difference to the legal analysis?
Yeah,
You need
it
to
does.
establish, and that's what I don't understand.
But the reason they've done it is because a loan direct from a company buys a tax charge.
Well, let's put that to one side because, as you said, you're just making the submission that you shouldn't be sort of focused on other provisions.
No, but it does explain why they've done it this way. They
No,
didn't
but
have a tax
I'm
charge
interested in the
before.
question, does the question of whether it constitutes remuneration or payment differ? Or are you looking for essentially the same fact findings about the circumstances of the loan in both contexts?
I'd say, in interrogating the question, is the payment for work done? The whole point of Rangers, as it happens, and my response, is that no one cares who gets the money. If that money had been paid direct to Mr. Currell, that would have been salary, taxable, or Section 60.
But I mean,
Juicy.
my proposition is where a loan is on exactly the same terms, but by the company directly to him rather than by his EPT or the EPT.
And I can see that they didn't want. So, to respond to the point made by the Lady Justice Falk, this is different to the point I was making that don't say this isn't taxable because there's other provisions in the statute. I'm saying the prospect of a 25% charge could well explain why they used an EPT. That's all I'm saying. They don't want a loan direct from the company. So what they've done is to say we'll make a payment to the EBT. That's the 800,000, no tax charge there, and the EBT can lend the money, no tax charge there. Not even the cheap loan provisions, because you're using that money to buy shares, and then that money goes back into the company.
But you might say the most obvious challenge to that is a Ramsey one that says, forget the EBT, this is in substance a direct loan. So, and if that was the analysis, then the loans to participators rules would apply, or would you say, and I think this is my Lord's question, would you say there was remuneration?
I would say it depends on the facts. If it was a tough place circumstance, which is what the FTT found in tough place, then the revenue could interrogate to say that loan from the company doesn't behave like a loan at all. So it's more than a Section 455 charge, it's more than 25%. It's earnings. Here, so that's a conversation that could be had. Here, there was an alienation of funds, not a loan. Why? Because he'd worked. That's earnings. To say, well, actually, they could have done it a different way, and what it's really doing, I think this is the intuition of the questions put to me. What this scheme was really doing was running away from a 25% charge on loans to participators, a Section 455 charge. And my respectful response to that is, well, no, that's not a finding of fact. The finding of fact is there was a payment made for work done. Nobody asked me to do this scheme. And that's remuneration. And the fact that it was paid to the EBT and then lent meant that in the taxpayer's eyes, there was no tax charge. If it had been paid to Mr. Currell, tax charge. If it had been lent to Mr. Currell, tax charge. But that payment for work done, therefore, let's pay it to the EBT. And they can lend them the money, no tax. Not even on the cheap loan provisions. So, what my respectful submission the court can't do is to say, well, in a world in which we're interrogating whether Rangers applies to that payment for work done, it would be a wrong analysis to say, we can infer it was in truth a scheme all to do with making a disguised loan from the company. You say the same about Rangers. Exactly, you can say exactly the same about Rangers. Why didn't the revenue just say it's a loan direct from the company and be content with the 455, what is now a 455 charge? Because that's not what was going on. It might be said, and this is why there's a danger of going around in circles, but that really was remuneration. So is this. It's work done. Especially when you look at the voluntary bonuses paid to the executives. So the point's been good to me, the intuition that, well, it's a sign-on analysis that's gone wrong because in truth, the real attack should be on a loan from the company. I say no. Not when that payment was made for work done. And you could have said exactly the same about Rangers. Please, may I show you Strategic Branding and CIA. It's in volume 4. strategic banding is behind tab 37. Start at page 954.
I take it this case wasn't appealed.
No, strategic wasn't, and neither was CIA. And it's all the same scheme. It's a payment to an EBT and then a loan. And I'll take it short. It starts at the please may I start at page 999, paragraph 195. So this is the FTT addressing my Ranger submission. That money paid to the EBT and then when that's earnings. That's for work done. That's what I was saying. And you'll see at paragraph at page 1000 the FTT sets out the test perfectly well. And then at page 1001 at paragraph 204 we didn't have the Marlborough argument. There was no argument, this was distributions. But the business end of the FTT's approach starts at paragraph 205, it's on page 1002. There's a link. The language of this, it resonates, the Upper Tribunal's language in this case. There was a link between the payments and his employment. There might also have been a causal connection with the shareholding, but there's no finding because nobody was arguing it's a distribution. But 206, the FTT judge says, oh, but look, it was a loan, and he therefore had an obligation to repay the loan. Accordingly, that's it. They're not earnings. And I wasn't saying the loan was earnings. I was saying the payment to fund the loan was earnings. And it's literally the same analysis. Literally the same analysis in CIA. It's behind tab 39, starts at page 1070. I'm going to take it short. Paragraph 200, page 1119.
So, in short, you're saying these cases take the long approach,
Because they're
although
focusing.
they weren't appealed at the time.
That's right. Exactly right.
So 1119.
Yeah, yes, my lady. Paragraph 200. And you'll see, you've got an obligation to repay. So it's asking the wrong question.
Oh, 200, thank you.
I'm sorry, my lady.
Yeah, I was just catching up. Apologies.
And so, and I know this because I was there. I never said the loans were earnings.
Can you just help me with the language of reward or benefit? Because that's something we see in a number of decisions, including the present case in the FTT. Help me with how that's come into usage, because that's not, you're focusing on paragraphs A and C. And it's not the language of those provisions.
I suppose that's right, my lord. Well, I don't suppose it's right, that is right. Reward, I think, is a perfectly fair synonym for remuneration.
Yes,
And benefit would be, I guess, because we're not talking about the benefits code,
no.
but some other way. I pay you cash, I pay
Yeah.
you butcher's bill or something of that nature. School fees, whatever you pick.
It's just become convenient shorthand, is it? But the crucial legislative provisions are you submit 62 to a C.
Yes. In the background of section 6, 9,
Yeah.
10, 2, 15 and 18.
I
Yes.
think the FTT here say they're using award and benefit as a shorthand.
Yes, they did.
section
They did say
62.
that. Yes. Yes.
There's no quarrel with both the FTT and the Upper Tribunal, the UT, in the setting out of the tests. They've set out all the cases. It's simply and the learned judge in strategic branding and the Upper Tribunal, she was careful to set out the test quite properly, but she was looking at quite simply the wrong thing.
The loan.
No, not in this case. I mean, in CIA and in
And that's what I mean. Yeah, I'm reading CIA paragraph 200.
Yeah.
I'm not satisfied that
well,
receivers
the
are
loan. I thought you said below. No, the loan. Yes,
Yes.
exactly.
Yeah. That's focusing on the wrong target, the wrong question.
Yes.
But for some reason, the FTT here treats it as though it's part of the target they need to hit, don't they?
In a different way. I'm going to show you the FTT now. I'm going to show you the FTT. I'm going to go through it. And I'm going to show you the UT. I'm going to go through that. And this is what, if it reassures you, we're fine for time. What the FTT did was they addressed the issue as whether the payment was earnings. So it got that right. They then interrogated, and these are the paragraphs that have caused all the trouble, 33 to 37, the nature of the loans. I said, well, they could be a reward and benefit, or benefit, but in my respectful submission, this is clear for two reasons which I think cannot be argued with. One, and they looked at that to explain. They looked at why the loan was a good thing for Mr. Currell, to explain why the payment. It explained that it's true that the payment was payment for work done by him. That's why they looked at that. They didn't find that the loan was a reward of payment, because having found the payment was a reward of payment and therefore taxable, if they actually found it was the loan, there would have been 2 tax charges. Nobody is saying the FTT found that. What the FTT did was ask themselves the right question and to work themselves up into a state, I accept that, in paragraphs 33 to 37 as to why a loan is a good thing. But all with a correct juristic ambition to find out whether the payment was a reward or remuneration for services. And that's what they found. Nowhere did they find that the loan was earnings, because as I've said, if that was true, there would have been a tax charge on the loan, there would have been 2 tax charges. And that would have been odd.
So we're going to the FTT decision
yes.
now.
It's in the core.
Core bundle.
Core bundle behind tab 10 starts at 1, 2, 3, and I know and I'm alive and I'm grateful that the court has looked at this. And I'll take it short, but that's what I say the FTT did.
I'm looking at paragraph 14
Sorry,
of the FTT,
yes.
page 126. You submit, they got that right. They posed the right question.
even the upper tribunals upset now. So can I beat it to it, because yes, it's going to show you 14. Then going on then, I'll take the facts short, but it's important that I've made good what I said the facts were in that note I handed out. So on page 127, this is paragraph 15. This is paragraph 15, little 6. So this is Mr. Currell being a driving force, not the driving, a driving force. Significant decisions would have to be approved by him. So that's the background of control I'm talking about. Employees, these are the contract managers. They were essential to the success of the business, and they got big bonuses. That's little 9. Little 10, that's where you get this proposition that together Mr. and Mrs. Currell control the company. Little 11, these are the numbers that I mentioned in response to my Lady Justice Falk about what he was being paid. 12 and 13 are the points that come to death. 14 and 15 tell you this scheme, its archaeology, came about with tax advice.
Well, 12 and 13 may be significant, at least the respondent would say.
Well, yes, and you've got my submissions as well.
Yes.
So I'm saying I've done them to death. I mean, you'll know all about it, I'm sure. But I say that the complete irrelevance. You can pay me more because I get it tax free. So what? And you wouldn't do it unless it is tax free.
Yep.
I mean, you've got the point.
Yes.
So you've got, as I say, 14. Little 14 this is, right through to 20 telling you about the background, and this was the notion that this is all pre-wired. Because the loan agreement, that was done before the money went into the EBT. And there is a mix-up and a confusion about, first of all, the shares held by Mrs. Currell at 24 and the money flows. I'm not taking anything from that. The company funded 800,000. So the EBT, the Upper Tribunal had something to say about it, but I'm not taking any point because it's impossible to tell, to have a proper record of the money flows from either how it's been recorded by the FDT and also say this respectfully by the UT. So you've got at 26 and 27, the respondent, the company says it's all about ring fencing. At 28, Mr. Currell understood the loan was repayable. Nobody's saying it's a sham. He could pay it back if he needed to. The trustees knew that. 31, you've got this double tax point. This is the reason formulation. And the trustee and the company were both concerned. It says the trustee and company were concerned if the money was repaid. I said the effect of that would be that the bonuses would be paid out of taxed income. All that tells me is that tax concerns have a part to play about how this loan is administered. Then you've got little 34. The trustees were reactive. They didn't make any positive suggestions. It was up to the company. You've got £50,000 repayment at little 35. and then they make additional findings of fact, and I think I have to accept that means that what they're saying at 15 are findings of fact, all right? It's not clear, but I think I have to accept.
What about heading do they put on that? Oh, that's all under the finding of the facts, isn't it?
Yes, but the problem is they then say the finding of fact is that somebody gave evidence.
Yeah.
So I'm not going to spend too long on it. Just
Okay,
it'd be useful
but
to know
yeah.
That they'd accepted the sentence. But I'm saying that we do have to do that. So at 16, some of this is replicating what we know already. It was all pre-wired. Tax background, all pre-wired. The payment back from Mrs. Currell back to the company was a loan from her to the company, and the trustee at little 7. The trustee wasn't going to pay back anything in the first 5 years on any money. And they're not going to be paying bonuses unless approached by Mr. Currell, that's 9, and didn't consider paying bonuses to the employees of the company before 2019. But despite the history of the bonuses, now I had thought somewhere that I know what it was, because I had thought the company had paid bonuses, but I think what the FTT had said was, I'm sorry about that, I take that back. If there were bonuses to be paid, the company would have found that elsewhere. I'll show you that. So it's then at 22 we get their approach. This addresses the point raised by my
Sorry,
lord.
the sub-numbering is so awkward. It's very
It's
difficult.
page 139, my lady.
Thank you.
2022. Is that all right?
Yes.
So again, 22 replicates what they have to find out about the payment. And everybody accepts you have to look at everything. That would include the loan. And at 24, we're still looking at the payment, expressly so. That's on page 140. And they set out the test about what remuneration is. It's from the employment. And that word "from" that replicates, in case you're wondering, the old section used to tax emoluments therefrom, meaning the employment.
Where are you reading
I'm
from?
reading paragraph 25, my lady, at page 140. And then at 27 and 28, what they say is, well, we don't have much in the way of evidence, so we have to make inferences. And then at 29, the respondent had made submissions about why this arrangement was put in place, and these are rejected. You see that at 30 on page 141. And then they give reasons at 31 on page 141. And at little 2, at paragraph 31, little 2, they record Mr. Currell saying that the loan was attractive. Then little 3 and little 4 and little 5 all tell you it was all pre-wired, and we know that. And then at little 8, the substantial and significant reason why the payment was made in order to make the loan to Mr. Currell, it was pre-wired. So that's the connection between the payment and the loan. And at little 9, they're rejecting the ring-fenced asset protection, creating a bonus pool reasons. And little 11, that's where I got this from. That's where I got that from. And then Mr. Waldegrave says, well, this is all very interesting, but you've just put 800,000, come on. What's all this about asset protection and what's all this about a bonus pool? But I'm not going to, it's not a useful use of my time to dwell on the rejection of these reasons. Those reasons have gone. There was no asset protection reason, and there was no creation of bonus pool reason. And you'll see the FTT saying that's all nonsense at 16 through to 19. And at 32, they talk about this ostensible reason. This is at page 143. And this is, in my respectful submission, a finding of fact. The substantial reason for the payment was to provide the funds to the trustees in order to make the loan. And then they, as I say, you now get these paragraphs that have caused all the trouble. Was the loaner awarded benefit? Now, it would have been easier for all of us if they'd headed that up. What does the loan tell us about the nature of the payment? It doesn't say that. It says, was the loaner awarded or benefit?
So you say this is not a question they needed, in fact, to ask.
Not so. They were entitled to ask and should ask, what does the loan tell me about the nature of the payment? And we'll see when we get to paragraphs, I think, as I say, it's 56 and 57. That's what they ended up doing. But here, they're asking a different question. I absolutely accept that. On its face, they're saying, could the loan be a reward?
But this doesn't come from nowhere.
Yeah.
This appears to be the language of the cases you've just shown us. CIA, for example.
We wondered whether it might have come from, yes, that and the brand.
And they were unappealed. So it may be. I'm not saying this is a point which either helps you or helps the respondent in this appeal. I'm just making the observation that possibly as a descriptive matter, the explanation for what's happened is that at the level of the FTT, this had gained currency, this way of looking at things. And it wasn't appealed.
Well, that's right. And the problem, my Lady Hale once said in the case in Cart, one reason we need the input of the higher courts is that what she called local law, without any disrespect, can get traction. So in a world where CIA wasn't appealed, strategic branding wasn't appealed, Marlborough, I did appeal, but I was refused permission
Yes.
to make this point. You can see how points like that can get traction. But rather than work myself up over that, I'm saying that those cases address the wrong question. And in any event, they're looking at it.
The trouble is that you're almost, I don't want to put words in your mouth, but you're almost saying that this tribunal has asked itself the wrong question.
Well, no, I'm not, because and that's not because I'm trying to avoid the issue or run away from what the FTT's done. I'm saying the FTT, having asked this question, and we're going to have to look at it.
Yes.
Went back to the right question.
Right.
But they identified as something they needed to consider along the way before getting to the right question, something you say they didn't need to consider at all.
I do say that. I do say that. So, and you're right. If I may say so respectfully, look at what they're saying. At 36, a genuine money of loan with real repayment obligations can comprise a reward or benefit. And what I had said so many times that I was sick of saying it in CIA, in strategic branding, was I don't care what an employee does with this law. That's what it said in Rangers. But anyway, who cares what I think? They were looking at this loan. So they're saying is, well, here they're saying there are all sorts of reasons. This is their big message. There are all sorts of reasons why a loan, qua loan, is a reward or benefit. They are saying that.
Yes. Can I just pause? As I understand it, this term reward or benefit, they expressly say they're using as a shorthand for section 62. They expressly say that.
I know that.
You have to, that is one of the challenges, I think,
It is
with
a
this
challenge.
passage.
It is a challenge, and I think the only way I can explain this is that must be sloppy because there are not two tax charges.
Well,
There was a tax charge in the payment,
but they define what they mean by
and if you well, I understand it, I'm saying here there cannot be meaning that the loan was itself a taxable reward or benefit, meaning remuneration. They can't have meant that because they go back in 56 and 57 and as saying that it's the payment that's taxable. So if this was statute, we would absolutely be in a world in which we're saying, look, we've got to sort this out. Here, I'm saying, well, there are not two tax charges. Nobody's saying that. So either it's sloppy and they're using the word reward or benefit in a way that they didn't mean to, or it's something else. But look, can I take you through these and then take you to 56 and 57?
Yes.
Because if and to the extent that the FTT below has expressed itself badly or sloppily or wrongly, they go wrong in law if they've asked themselves the wrong question or used material that they shouldn't have looked at.
Yes.
There's no Edwards and Bairstow challenge on primary findings or inferences. We've seen the question that they are asking themselves, you've seen it, is to do with the payment. It is the payment. So you can't trump that by saying, because they use the word reward and benefit in the Ranger sense, the Lord Horde sense, they must be looking at the loan as itself a taxable emolument. They can't have meant that.
Well, that's not all they're saying. I mean, I don't want to take you out of order. I'm focusing at the moment on paragraph 37, where they summarise their view on this little section of the judgment.
Yes, my lord. Can I get to that?
Well, yeah, of course, yeah.
Because,
But I think you are going to have to persuade us that they haven't fallen into error as a matter of law there, because they say its payment to MC, therefore, was potentially within the ambit of section 62, it being the loan.
and I understand that because that's very firmly it's front and centre of what the respondents say.
Yes.
And I'm saying they can't have meant that loan is taxable. That's not what they held. So can I finish? Because so there's all this reasoning as to why a loan is a good thing. Until little 8 on page 144. Little 9, so little 8 is where they finish. In paragraph 26. And this is why I'm saying this, I stay respectful, this is sloppy because they seem to be, they say they're dealing with can loans be rewards and benefits in principle. But in little 9, they've now turned to this loan. And they're saying, well, look at it. It's all to do with this loan. Interest free, repayable, but not demanded, genuine loan, repayment obligations. Little 11, it conferred a benefit on him subjectively and objectively. financially advantageous compared with borrowing from a commercial lender. 13, he got in at 800,000. He's paying 50,000 back. But anyway, the big message is this loan confers a benefit. Then, my lord, absolutely. As a matter of law, there is nothing which prevents a genuine money loan conferring a benefit. Vast majority of cases, a loan will confer a benefit. In this case, this loan, they don't say this, but they conferred a benefit. Its payment was potentially within the ambit of Section 62.
Therefore,
Hmm.
it's potentially.
It's payment to MC.
Therefore, was potentially with. I don't need persuading. That's what this says.
Yeah.
The question then is, did that mean that they answered the wrong question when I show you paragraphs 56 and 57?
Well, I think we should also just note the final sentence of 37. Whether it was earnings depends on the substantial reason for its payment. So
Yes.
that's clearly asking, was the loan earnings?
Yes, it is. I'm not disputing that, my lord. What I'm saying is, having focused in these paragraphs that have caused all the trouble, having focused on the proposition that loans can be earnings, vast majority of loans are good things and beneficial. We think this loan is potentially within Section 62. Did that mean, does that mean, when we look at 56 and 57, they erred in law? So they've asked themselves a question they shouldn't have been asking in 33 to 37. I understand that, I get that.
If
Does
you put
asking, sorry,
you put a line through everything that began at the was and but kept the word whether it was earnings depends on the substantial reason for its payment, you would say you're still on track to the correct question and the correct answer.
I do, my lord, and that's why I'm saying that nobody is saying this judgment couldn't have been better expressed, more clearly expressed, and they've asked themselves a question they should not have bothered asking. And in that conclusion of 37, what they're actually saying is an echo here of the exchange you had with my lady Justice Falk. Is what they're saying is, if this was a different case where the revenue were pursuing Section 62 and just the loan, I would think so. I'm not interested, but they are saying that. That's what, and they are saying that. Oh, that's effective enough. You know, in the adverb. That's what they're saying. If the revenue had been chasing the loan, yeah, we think so. Potentially, that would get you. Nobody's interested. No, I take that back. I didn't mean to be disrespectful, but they didn't need to do that. That doesn't mean they went wrong with the answer to the question they actually needed to answer. That would be just like, if I may say so, engaging in speculation that you shouldn't be engaging in by saying, well, maybe they were actually disguising a loan. Maybe that's what was going on. And if you thought for that, maybe who knows, you would have won. No. They are saying, in terms, potentially if the revenue chased up the loan, they might have won. But then 38, 39, they're saying, why was the loan made? I'm pretty short, the business end of that analysis is at paragraph 50. and 50. He was buying access to the company. 800,000. And yes, in order to escape the cheap loan provisions, he had this transaction where he buys shares from his wife, Mrs. Currell. But that's really not a problem. He would have had no misgivings that she wasn't going to help him for their mutual benefit. That's what he was buying. And at 52, why was a loan made? He says, well, he's an employee, they pay bonuses, the trustees are reactive, must have done some work. And then at little 9, more than just some work. This is where they say he got less in salary and dividends than the contract managers. It's the very last line of little 9. So what we've got so far, if they ask themselves the right question, what's this case about? It's about the payment. A kind of excursus. You say, if you take it a different point, you know what you might want to know.
Well, they don't treat it as an optional excursus, do they?
They don't say one way or another, my lady.
Well, hang on, let me just find the parable. Page 24, we start there.
Oh, sorry, my lady, what page is
In paragraph 24,
it? No, I meant what page you...
page 140. They don't. I'm struggling with the point you've just made because I can't see anywhere that the FTTs suggest that 33 to 37 is either sort of optional or an alternative way of looking at things. And I think we'll come back to this when we get to 56.
Well, if you hold that thought, because some judges, some more than others, do this, the same excursus, because this is kind of interesting. What they've done, no, I'm not looking at really, I'm just saying some judges do. But what they've done is ask themselves and answer a question and answer it, which they didn't have to do. But then what did they do with that? And this will then respond to the point made by my lady, Lady Justice Falk. Because at 56, we have found that it was inevitable at the time that payment was made that it would be paid by the trustee to Mr. Currell by way of the law. We've also found it was more likely than not that the loan paid to Mr. Currell as a reward for services. This is what I mean. That's how the trustees viewed it, as a reward for services which he had provided to the company. No legal principle which prevents a this unnecessary point again. That prevents a genuine money loan with a real repayment obligation from being a reward benefit. In these circumstances.
So you say that last sentence is an unnecessary diversion?
Yes, I do, because therefore, do you remember I was addressing my lady on this question about the inference? 57 says the payment.
In these circumstances?
Yes, my lady. And what they're saying, and this is the highest, in my respect and submission, you can put this point. What they're saying is, we infer that the payment was a remuneration, because that's the therefore. Because what we see in 56 is that one, the trustees made that loan for worker as a reward for services. That would have been enough. They also say, and what's more, and this is the point raised by my lady Justice Falk, a loan can itself be taxable. And that's why I haven't shown you it because it's not, I don't need to. The FTT here says, oh, we disagree with Judge Zaman in what she'd said in CIA and whatever the other one was, strategic branding.
Yes.
So, I think my Lord Justice Singh is right. They're having a kind they're engaging in a judicial debate about a question that should never be asked. That is true. Judge Zalman in CIA strategic branding focused on the law. I didn't ask her to, I didn't want her to. They focused on the law. Their legal analysis of a loan potentially being within section 60, there's nothing stopping it being taxable, if I can put it that way. That's what they found in 33 to 37. That was one of two reasons in 56 that they looked at. The other was that the trustees made the loan to reward Mr. Currell. Therefore, the payment, because everybody knew that's what the payment was funding, was made for the same reasons.
Yeah.
But the knowledge, if one is going to stress test this, and with your permission, I'll finish, and I'll pick it up after lunch.
Yes.
The purpose of the payment was to fund the loan. What the company knew was that the trustees would pay money, the loan to Mr. Currell, as a reward for the work he'd done. That's what informs the purpose. To say that another reason was because they thought the loan could be a reward or a benefit taxable under section 62, that makes no sense at all. That's why I'm saying this is sloppy. What informs the purpose of the company is what the company thought the trustees would do with that money. This excursus, and this is the question for this court, it was the question for the Upper Tribunal. Did that excursus, this loan could have been within section 62, does that infect what the FTT has done in 56 and 57? Asking the unnecessary question, coming up with an unnecessary answer. And in my submission, no. It doesn't infect. It will come to a different answer. So that is my proposition. I'm trying not to keep saying it, but the purpose of the loan is the purpose of the payment is the purpose of the loan. That relevant purpose is payment for work or services. The legal categorization of the loan as something potentially taxable in itself. That's what this court has to grapple with. Is that enough to infect the tribunal's decision as an error of law? And I say no.
Yes.
But please may I stop there?
Yes, certainly. Now we're very happy to hear Mr. Walgrave follow you this afternoon. But can you just tell me how we're doing for time overall?
Fine, is the short answer. The longer answer is I'm done with the FTT decision. I only have to show the Upper Tribunal decision. And the rest of the afternoon is Mr. Walgrave developing Grandstein 4, and we're
That's fine. That's fine. And I hope the message was conveyed to you that we must finish by 4:15 today.
Yes, it was, and we will.
We'll sit again at 2:05.
Court rise if you will.